Also would hope that the court will consider the jail calls as well, because I think that truly solidifies why Mr. Farley cannot have a bond. But additionally, Your Honor, there's been no change in circumstances, although the only difference between what Mr. Geary, he believed that the gun and the phone had been recovered. That was the only error. Other than that, everything he said was accurate, and the jail calls do reflect that Farley attempted to hide these items. He is charged for murder. And again, it does look like whether or not he currently has a cell phone in his possession, that photo being posted so recently of a selfie, it's not a picture that someone took of him. It's clearly that he took of himself while giving a middle finger. It's attached as Exhibit A in the jail. Would support the denial of bond, Your Honor.
Very just briefly, just want to cover those things. Just the mere fact of facing a murder charge doesn't make you a bond risk. Otherwise, everyone that's presumed innocent and accused of murder wouldn't get a bond. And again, Judge, it's not YSL apparel. That's the part that Don Geary left unanswered last time. I don't want to get the state any ideas, but on the Make America Slime Again Instagram account, Mr. Williams is not the only one wearing the clothing. And Make America Slime Again has nothing to do with YSL explicitly. There's also artists like Future and T.I. on the Instagram wearing the same hat as Mr. Williams and that same shirt that Mr. Farley's wearing on the BP video, Your Honor. And the shirt says slime or die. It's just a play on words like trap or die. Your Honor, again, the state still by their proffer in a black and white way has failed to articulate any party to any crime. If you listen carefully to what Ms. Rosenwasser just said, all she talked about was presence and association. He's at the BP. He's with these people afterwards. He's wearing a shirt that has the word slime on it. Your Honor, Make America Slime Again is an LLC. It's an official company. It has nothing to do with just YSL. It was Mr. Farley's attempt to get any proximity to any artist of any kind of attention when attention is such a commodity these days, especially for the clothing business. And if you notice too, the shirts that Mr. Wani Lee is wearing in his videos, because Mr. Farley and him are close friends from since they can even remember, and he is his personal assistant paid by Alamo Records in an official way. Mr. Wani Lee is also wearing shirts from a different clothing line. I think it was True Detail or something like that. And it's some relative or other person that he's trying to put on. So Your Honor, this is not YSL apparel. This is a person, an entrepreneur who is close to Wani Lee, has a business relationship with him, and then networks with musicians and other types of people to make his clothing more visible. And so, Your Honor, again, there's just presence, there's just association. And as far as access to a phone, that doesn't show anything. It shows that he's on the phone in the jail, but it doesn't mean that it was his phone. It doesn't mean that he posted it. That account that did the story wasn't him. You can reshare stories. You can post stories of other people. So just like when we had that proffer about Mr. Kitchens, where someone said, oh, I'll do anything for Gunna. If someone wants to post something with an image that they somehow got because a camera from a jail phone was on Mr. Farley for a second and took a picture of him giving the middle finger, okay, he didn't decide to post that. He didn't decide to someone say free him or anything like that, Your Honor. So again, I don't see how being in a phone image makes you a risk on any of the bond factors, Judge.
I'll listen to the.
Okay.
And severance. So I'm not going to bless this about that time. So I'm going to take 10 minutes and then we'll come back and I'll finish up the meeting.
Thank you, Your Honor.
Should be provided. y'all, I think they took a recess. I think they took a recess. We're going to see. We'll give them a few more minutes to see if they're going to come back on. But I don't think that court is over. But how is everybody doing? I decided to get on the vlog about this, but I actually got a live that's coming on in about 3 hours. I think they're getting ready to come back. Hey, Roberta. So do y'all think that he's going to get, do y'all think that it appears, just to me, it kind of appears that he's winning. I think he's gonna get out. He got some really good lawyers. I promise you, he got some really good lawyers. And what they've done is they've used little small oversights to their advantage of the prosecution. Yep. He said he was taking a 10-minute recess. Okay, a 10-minute recess. Okay. Yeah, I think he's going to get out. I personally believe that he's going to get out. I do. Like I said, he's got some good lawyers. And even though I think the prosecution did a good job, what they did was, it was a lot. It seemed like that they did some careless stuff as it relates to the law. Some oversights, like forgetting to give him his stuff back. His lawyers have used all of that to poke holes in their cases and using it to their advantage. And I'm sure Thug is paying them a lot of money. That's what they're supposed to do. Hold on, guys. Move. Oh no, his lawyer is not a joke at all. I can imagine that his lawyer is probably getting paid. He might be paying him about $2,000 an hour or more. Gunner claimed that he didn't snitch. What y'all think? He said he did. He may get out something, but he's going to get some time. So y'all think he's going to get some time? I think it's him that they mainly want for some reason. Gunner never had the charges that he had. So it was never really Gunner. It appears to me that they won it. I think they held Gunner there all that time until he broke. If he snitched, he broke. Because he never did have the charges that Thug had. Roberta said he's a rat all day. He is getting his money. Yeah, he's getting his money's worth for sure. He's a damn good lawyer. He plays dirty too. Because I think it was his defense team that leaked those witnesses' names. He know damn well they did that. They did that to get those witnesses to back out and try to play innocent and say, this is hurting my client. I said to myself at that, I said, oh, that's a dirty lawyer right there. I think the prosecutor knew that he did it. Yeah, it's Young Thug that they want. I think he's going to get some kind of time, but not what they started out to get. Y'all think what, he'll get 3 years or something like that? Shoot, by the time that these defense attorneys get through with him, I hope he can get out and sell some. He could probably get out and sell some more music. But if he wanted, run some type of illegal organization, as they say he was running, he's probably going to have to leave Atlanta. Is Thug originally from Georgia, or is he from Louisiana? Where is Young Thug originally from? Oh my God, I saw that. They brought in all of those federal entities. They ain't playing. The FBI ain't playing for Houston. They brought in all of those federal agents to take down them folks in Houston. And they brought them in from different areas. TB21 says, I think the DA got something in their back pocket that's going to stick Thug. Shoot. Gonna hurry up and put that statement out because he didn't want to lose his street creds. He said he ain't told nothing. But then he admit that they was a gang. That's probably all that the DA wanted because they feel like Young Thug was the one that was funding the organization. Eric says the industry would take care of his switch hidden self. They promote his kind. Yep. Thug is the one that liked to wear the dresses. I don't know anything about his music. I'm gonna tell y'all why I could never get into Young Thug. When he first came out, I think Cash Money and them got him to try and replace Lil Wayne. You just can't replace Lil Wayne. I don't know a whole lot he's doing now, but Lil Wayne just had that distinctive sound. Like Lil Wayne was on fire. I loved his music. And I could never get into Slim Thug because he came out wearing pink and wearing dresses and calling baby my love. And that, I remember an interviewer asked him about that. He said, I don't have no problem with calling him my love and all of that. I couldn't, it was like they put him there to promote a agenda. And we already knew how baby got down, right? So I just could never get into the music of a rapper that wear dresses. I'm sorry, I just can't do it. So I've never, they're on recess. He said she tried Alim Thug. They on recess for 10 minutes. Yeah, Young Thug. Did I say Young Thug? Because I got a issue. I be forgetting to say I'm saying Slim Thug. I said Young Thug. Did I say Slim Thug? I be forgetting to say, I don't know why. I love Slim Thug's music. I like that screwed music. Slim Thug was hot back in the day. I always call Young Thug Slim Thug. Slim Thug and Young Thug are completely different. I mean, Young Thug. I hope I didn't put that up there. Okay, I did say Young Thug because I be forgetting and saying Slim Thug all the time. He can rap. I ain't never been a child. Juju gone home. Did y'all see how her eyes? I mean, she was wide awake at 6 a.m. this morning. And she got to be back tomorrow. So I was like, oh, Lord. She don't want me to do no work. She want me to hold her. She want me to, child, she's something else. She want me to talk to her, and she want to eat. And my daughter gonna say, Mama, she used to listening to my heartbeat. You have to put her up on your chest. I said, girl, please. Yes, Slim. Okay, y'all, here they come again.
Who's that?
Oh, he was right under the door. I can check on him.
Okay, all right. Ms. Rosenwasser, I understand that your technology issues have improved.
I believe so. I think we just tested it. It's got to,
We'll find out.
all right. So
Okay, so this is the jail call.
this is number one, and I'd like to just be able to respond after each one.
All right, that's fine. Let's play jail call number one, please.
Okay.
A free call from an incarcerated individual at Fulton County Jail. This call is not private. It will be recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number. Waiting to receive a phone call can be hard, but now you can easily and quickly send messages to your loved one. E-messaging is now available to help you stay more connected. Download the Securus app to sign up. To accept this free call, press 1. To refuse this free call, thank you for using Securus. You may start the conversation now.
Hello.
Yeah.
What's up?
You tell me. The fuck up.
What you doing?
Huh?
What you doing?
Crying my eyes out.
You ain't got to cry, man. It's all right. These folks come out, I done shot and killed somebody, man.
What?
Yeah, that was his thing on the sign. He said, accused. Like, he said, I'm the one who, well, I don't know, this shit counts.
Yeah, so what the fuck? I can't. I'm confused.
Huh?
Shot and killed somebody.
What they do when I left?
They didn't do nothing. They came ask for your phone, but I didn't know. I didn't put no phone
Yeah.
to get nobody.
You still got that number I gave you? You had I called my dad.
Yeah.
What did he say?
He said he called a lawyer, but lawyer answered. He said keep him updated.
I need you to get Bob on number, man. So I can got that. No, hey, look, matter of fact, call Lexi, baby, dad. You see what I'm saying?
Call him and say what? I was just talking to her. Call him and say what?
Yeah, tell him. Goddamn hit breakfast. He know what I'm talking about.
Say Miles said get bro for him.
Yeah. Send them folks down here.
Okay.
These folks trying goddamn murder, gang charges, and like they saying I'm trying to like get more ranking in the game. That's why I guess that's why the shit I did, whatever the shit they accused him, he's like it's for initiation, like a higher rank in the game. Like that shit happened.
Yeah, it's tripping. Yeah, but that's why you just need to cooperate and do what you got to do to get on up out of there because you have a son.
Yeah.
So you can't be thinking about nobody else or what nobody else got going on. You got to think about you because don't nobody give a fuck about you but you. You can't be thinking about what them folks on. I ain't trying to say, but
yeah.
You just need to think about M Day. That's all I'm saying. Think about him.
Stop.
And yourself, baby, you can't be in there.
What you crying for, man?
Huh?
Why are you crying? Why are you crying?
I'm not crying. I'm not crying no more.
I need you to get that number for me, bro.
You acting like you want me to call on three-way or something.
Nah, hell no. Hell no.
Okay, I mean, but how would you get the note? Like,
Call on three-way.
this number, number. Oh, wait. No, her number says I can just add the call.
What else they doing?
Right here. Hold on, I'm calling.
You heard what I told you, what I said before I left? Huh?
She ain't answer.
Damn.
But I was just talking to her literally like right before you called.
You have 1 minute left.
I said, you heard what I told you before I left?
What you say? No, I didn't hear you tell me nothing. I love you too, man.
Don't let me fuck you there, bro. Stop crying.
I was going to cancel my claim, but I'm going to keep doing it. I ain't gonna.
Hey, listen, I'm going to give you my Wells Fargo thing so you can go in there and zero that money to you. It's $1,200. I got to give you the login. You know what I'm saying? So you can zero.
What? You didn't ever get that money?
Yeah,
So when you going to give me the login?
I'm going to give it to you. I got to call. I'm going to hang up and call it.
Oh, so you can call it. I'm thinking you ain't finna call it.
I'm saying, he said I can give you the phone. Though. They said I got court tomorrow at 12.
I know, that's who right before you called, that's who I was trying to get on the phone with to get the link. He said,
To get the
so I can send to you. The link, the Zoom link. So I can watch it.
Thank you for using Securus. Goodbye.
So, Your Honor,
That's call number one.
that call is relevant because of the context of the other calls. So what is notable about that call is, first of all, he discusses his charges, so I think that's always going to be relevant. And of course, the relevancy standard is really, really low. The question is whether this is in any way relevant, and it is. It's not, the only evidence by any means that we have against him. It wouldn't be enough to convict him on that call alone, but it's relevant. What's particularly important here is that in this call, the called party tells Farley that law enforcement came and asked for your phone, but I didn't see no phone to give nobody. So that goes into the next few calls we're going to hear. It essentially sets the scene for the remaining 3 calls. So if the court would allow us to play the second call now.
Okay, all right.
Call from
Wow.
an incarcerated individual at Fulton County Jail. This call is not private. It will be recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number. Waiting to receive a phone call can be hard, but now you can easily and quickly send messages to your loved one. E-messaging is now available to help you stay more connected. Download the Securus app to sign up. To accept this free call, press 1. To refuse this free call, thank you for using Securus. You may start the conversation now.
Hello.
Mm-hmm.
Hey, look, when I call, they hit 11111 so many times, you ain't got to go through all that. They're going to straight accept the call.
Okay.
But goddamn, this shit crazy, bro.
Yeah. Them folks did tripping. I don't even I came to the door with drugs on. I don't even put on my goddamn door. I mean, what I'm saying.
Yeah. It's alright, bro.
I can't hear you.
I said, you know what's up, though? Like, you hear this?
Yeah, but
Shit, cap it hell, man.
I know, but at least you know anything coming like.
I be bringing them from your house.
Yeah, I don't want to just. How the hell they get that address?
So I don't even know. Like, I don't know.
Exactly. Somebody had to say something.
But goddamn, get what? Well, you said they were looking for the it's in the hairball.
Huh?
It's in the hairball.
So, Your Honor, I paused it there. If the court could hear, Mr. Farley said, so what they were looking for, it's in the hair box. That refers back to the call. And I do want to be clear that these 4 calls are all on the same day over a very short period of time. So he just said, so what they were looking for, it's in the hair box. We'll continue the call. I just wanted to flag that to the court.
Hair box.
Yeah.
Hair box.
Yeah, listen, do not cut that motherfucker on. Hey, like, go throw that motherfucker in. Like, you feel what I'm saying?
What?
And so, Your Honor, that's where the defendant said, do not cut that, go through that. And that is, obviously, Mr. Farley's contention was that that was because he believes it contains unsavory character evidence. I'll believe that the jury could interpret it as the state has, which is that the phone would be evidence that the police were seeking. So we'll continue with the call.
Okay, man.
Yeah, you ain't hear them folk outside.
You know what they were saying?
They was at the window and shit. I heard them. Like, I ain't really want to get no sleep though. But
You heard what they were saying?
they was like, we finna come in and shit. That's why I woke you up.
You woke me up? I don't even remember. I just remember this and screaming.
I had no grab MJ.
Yeah.
Crying.
Mm-mm.
Man, that shit crazy, bro.
That shit is lame. What the fuck?
I'm saying though,
And Nick,
I ain't finna keep going through this shit with you though, bro. Like, hell no. I got a little boy. I'm not like all that back and forth shit what we be going through. Like,
that's you, man. Like,
you really with a nigga though, but you know.
we got less. You want me to answer?
Yeah, hurry up and answer right quick.
Just you go. My phone just went short.
Yo,
Oh, hold on, let me get the phone.
hello.
I'm finna get on. What's your phone on? I think it's finna hang up too much. Go ahead. Yeah.
Yo, my boy.
What's up, bro?
Holla at them folk, baby. Them now.
I'm already on there right now. I just talked to him. My wife said they're gonna call back when they wake up. But he just told me.
Alright.
You good? What did they come out?
They said I got I shot and killed somebody. Then they say gang charges and goddamn initiated to get ranked. Like I'm trying to do the shit for rank.
You have 1 minute left.
That shit sounds so damn goofy, man.
Man, what? But you know how that
But
shit.
shit, I'm already on that shit, though. I'm finna be on bro ass, though, but it more definitely go, though. Shit, I didn't wait till wake up.
Alright. Then I'm calling.
I didn't love you.
Love you too. I love you.
Yeah.
The phone finna.
I don't know. I ain't need to.
I'm finna call you
No,
right
okay.
now.
Oh, okay.
Alright.
The caller has hung up.
Okay, Your Honor, we'll move on to call 3.
Yes, ma'am, go ahead.
Call from
Yeah, Jay.
an incarcerated individual at Fulton County Jail. This call is not private. It will be recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number. Thank you for using Securus. You may start the conversation now.
hear me? Hello?
I hear you. Yeah, can you hear me?
Call my dad right quick. Man, this shit lame in here, man. Fuck.
Yeah, Rice Street.
Yeah.
Which number, man? 770 or?
Yeah, call that one. Call that one. Hello? Yo, what? Hey.
Yeah.
What?
Yeah.
Where you at?
The shop.
You busy? You got somebody in the shop?
Yeah.
All right. Now I'm finna say go by the house right quick.
Who house?
You know what house?
Oh, okay, but what name? Say you gonna come down now?
Gee, get what they saying? They say, man, I shot and killed somebody. Then they say the gang charges. Then they say the reason I did it was to get ranking initiated or something.
So what is that?
Yeah, you know that cap. I ain't did none of that.
So where you at?
All right, I'm down here. I got court tomorrow at 12.
Okay.
But I need you to go to the house and
Okay.
and get that stuff.
From me, man?
Yes.
Huh?
Yes.
Okay.
So that my gun under the bed though, you can leave that under there.
Mm.
So, Your Honor, at that point, after the court heard, Mr. Farley asked it sounds like another person that he had the call party call and instructs that person that he needs to go to the house and get the stuff. And then he specifies my gun under the bed. So I want to relate that back to the bond motion. Here we are talking about covering up the cell phone and covering up the gun. That's exactly what happened based on those calls. And obviously that's relevant also going to the jail calls motion. And we'll keep going.
Okay, but it's, all right.
Hey, listen.
He hung up, man.
You know the one. You know the one.
Uh-huh.
Yeah, get him that.
Okay.
What you finna hang up on?
Huh?
You don't want to talk no more?
No, what are you talking about?
Oh,
I mean, I just said, okay, I got you. Like, what else you want me to say?
So it's trolls in here. What are trolls at so I could block them? He said he get ready to get in trouble for three-way calls in jail. Hold on, they back.
I seen it.
Yeah, get him.
You want me to give the other one like back to him that's behind the bed?
Nah, hell no.
Or just the three, what you call it?
Yeah, give him the 3. The 3.
Yeah, okay. And that's it?
And the other that thing, bro, that I be riding with. You remember the one I gave you?
Okay.
You remember the one I gave?
Your Honor, the defendant just instructed the called party to give him the 3, not the one under the bed. I think from context clues that would suggest, or at least have enough probative value to suggest that there are 3 other items, perhaps guns. He also references not the one I've been riding around with. Again,
Yeah.
Keep that. But the other one,
You never gave it back.
I'm telling you, can keep it. It's under the thing.
Oh, so that's the one that's under the mattress?
Yeah, it should be 2 under there. At the
It's
end,
one. That's what I'm trying to tell you.
go to the right side. It's always at the right. Unless they got it.
You can't call back in.
Yeah. Unless they got it, it's always at the right.
It's one. Oh, I didn't see that.
Thank you for using
So which one?
Securus. Goodbye.
and Your Honor, now this is the last call that Mr. Farley's contesting.
Okay.
This is a free call from an incarcerated individual at Fulton County Jail. This call is not private. It will be recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number. Thank you for using Securus. You may start the conversation now.
Yeah, he just said I got to wrap it up. I got 1 minute left. Shit, you got now. If you can take songs, what we gonna do to hell? You know what I'm saying? But I'm gonna call you.
If I could do what, Mal?
If you can take it up there to him, you feel what I'm saying? Before you go do that, like on your way to do that.
I was going. You go to watch. We go to leave the house. I was gonna have her come here.
And Your Honor, this is the part that we believe is relevant on this part, which is that he asked the called party to take it up there to him on her way to go do hair. And Your Honor, we'll stop there. We know that the court's heard a lot of these. The court, we're welcome to play the rest of this. We'd like to hear it.
I'm good.
Okay. And so at the court's pleasure, I do have argument on those calls that we heard.
All right, okay, well, go ahead, let's see the argument.
Okay.
Start out with call number 1.
Your Honor, so what's important here, and this is I'll go first with the motion in limine, and then I'll reference it back to the bond hearing. As to the motion in limine, each of these calls is relevant when considered in context with the other calls. So call 1 is when the called party references the fact that basically people came to the house looking for something. Then in the following calls, it details Farley's attempts to hide the item that the officers came looking for. And I think Farley seems to even concede that the item that they were looking for is a phone, because he says, don't turn it on, go throw it away, essentially get rid of it. And he now contends that that's because he was having, outside relationships, but we don't know that. And the jury doesn't know that. That's a matter of interpretation. It's enough to be relevant. And he can argue at trial what he argued here. That's a perfectly acceptable argument, but nevertheless, it doesn't make it not relevant. I think that leads us into 2. It's just where he says all that. And he says it's in the hair box, and he says where to find it, and says not to turn it on. So I think that's enough to be relevant. Relevance is an extremely low bar, Your Honor, and that is enough to be relevant. And there's nothing prejudicial about it. He never says, don't turn the phone on because I'm cheating on you. He just says, don't turn the phone on. It doesn't go into any kind of extramarital affairs or anything like that. He's welcome to interpret that however he'd like to, as is the jury, but it's relevant. It's nevertheless relevant to show that he is, in the state's contention and based off the recording itself, clearly trying to hide something that they, quote unquote, came looking for. As to the third call, I think this is the one that essentially is why the other calls are all relevant and goes into this third call. In the third call, this is when Farley instructs the called party to give, quote unquote, what they wanted to Farley's father. And another caller then joins the call. Farley discusses the case. And then he instructs the third person added to the call to go to the house and get the stuff. Farley references a gun under his bed. Farley also tells the called party, you know the one, give him that. He repeatedly references what they wanted, and then he references giving all 3 items to his father. Farley instructs the called party to look under the mattress, explaining the one she can keep is under the mattress. That goes back to the gun. Farley also references the phrase is the one I be riding with, and he says that the item is all the way at the right unless they got it. So he's clearly giving instructions to an item. It would suggest from context clues that that is a gun. Call 2 obviously concerns the phone. We have suggestion from context clues that that's what it means. Finally, in the 4th call, Farley instructs the called party to take the item up there to him, that is to another location. Considered together, this shows that Farley made efforts to hide evidence or items for which law enforcement came to the house looking. The relevant standard, Your Honor, is very low. This is enough to be relevant evidence. It shows that Farley is trying to hide something, arguably a cell phone and a gun. That's what it suggests, at least to my listening of it, and I believe it could certainly suggest that to a jury. I also think his discussion of the case itself is relevant. Obviously, in the first call, the called party, suggests that he cooperate with law enforcement. I think that's all relevant. So first of all, Your Honor, we'd ask that this court deny Farley's motion in limine. As to the bond, it goes back to what I said before. For all the reasons that I stated previously, including that Farley clearly, as Mr. Menendez, we aren't saying he personally is owning a phone right now, but he clearly had access to a phone in the jail based on that photograph. Additionally, Your Honor, he's charged with murder. That is a very serious charge. He was charged with that before he even got these additional RICO charges and the charges in this indictment. Your Honor, this goes back, back to point 1. He's charged with murder. That was a homicide involving a shooting. So I think the existence of a gun is going to be even more relevant to that. But back to the bond, Your Honor, this is extremely relevant information. The state never lied about the contents of the jail calls. The court just heard them. I think it's clear from the jail calls that Farley did try to hide a phone and a gun from the authorities because he asked if they even referenced if they didn't get it when they were there. That was even a reference in there. So I think, Your Honor, that this court properly denied Mr. Farley bond. My understanding is that this case is going to trial within the next 2 to 3 weeks. And so we'd ask that this court continue to deny him bond and to also deny his motion in limine. Thank you.
As for the motion in limine as it relates to the jail calls, the court does find that calls 1, 2, 3, and 4 are in fact probative and relevant, and especially in regards to the potential evidentiary value of what the state demanded is the trial and the conversations and context that may be relevant. Also related to the phone and the gun, there is some evidence to believe that this phone and gun tried to be attempted to be hidden or secreted from the authorities. I do believe, as Ms. Rosenwasser has indicated, that it would be relevant for the purposes of bond, and for that reason, I'm going to deny bond.
Thank you, Your Honor.
Maybe we have a written order on the.
Yeah, if you prepare a suitable order on both those matters, please now.
Yes, Your Honor.
You can show that to Mr. Menendez and we'll prepare that.
Yes, Your Honor.
Just one note with regard to this evidence. You admitted it, but you admitted it against Mr. Farley. This doesn't resolve the 801D2E issues with regard to everybody else. So I want to make sure that, it's got 801D2E issues. We've got Bruton issues. If his jail call comes in post-arrest with regard to everybody else in count 1, and I do not want to acquiesce to that.
And Your Honor, we do have a separate 801D2E motion. So I think that could be addressed at another time.
And that's correct. I just want to make sure that with regard to these particular post-arrest statements of a co-defendant, we've got several substantive issues before they can come into trial, not just against him.
On behalf of Mr. Stillwell, I join in Mr. Harvey's.
Mr. Harvey and Mr., I would ask that you more or less listen.
I filed an 801D2E, and I think there are
So
motions
you'll
pending.
you'll need to file a supervised motion.
I did.
Not you.
Oh, I'm sorry.
Yeah, the other, strap hangers, Mr. Harvey, okay, that adopted your motion, need to particularize their own motions, because it depends upon what it says as to whether or not it's initial or not.
Right.
So, saying it's a proven issue, whatever, we need to identify the statement and give some particular type of, discussion as to why, as to, what the court can consider.
Okay. I have filed such motions, but not towards this
Well,
particular statement.
look, a lot of folks, just particularize, a lot of times, that's what usually happens, the court has to kind of look at each statement by itself as it relates to, that particular offense.
You're entirely correct. Let's, as far as it goes, however, your lordship, but let's flip that a little bit. We filed a motion saying, hey, look, what 801D2E potential statements or statements of co-defendants are you going to use? So that we file a motion in limine, but you got to tell us what you're going to use, like this one. So we can't particularize this whole mass of statements.
Mr. Rosenwasser, you're gonna need to
There
kind
you
of parse out and do a little homework, whatever it is you decide, sit down and talk in this decision, because it will affect your opponent's opportunities to, file.
Your Honor, as we stated in our motion, we would just ask that they let us know what they're objecting to so we can respond to it.
Okay, Mr. Harvey's saying that you need to identify what statements you're gonna, like, for example, you're gonna introduce statements again, involving defendant A. You need to go ahead and let them know you're gonna do that. Why is that important? Because if defendant C says, well, that implicates me, then I need to be able to respond to it.
Your Honor, we provide all the statements we have in discovery. I think generally because it's a RICO, everything's going to apply to everyone. So if they could just object, it's going to be a lot easier for me to be able to prepare a response, because generally our position is that all the co-conspirator statements, they are going to be admissible against everyone. So that's
Yeah, given the type of case, but to the extent that you can, and it will affect, because then I would certainly advise you.
A blanket statement that every statement everybody ever made since 2013 is a co-conspirator statement is blatantly overbroad. For example, this post-arrest statement from Deal telling someone else to do allegedly something, and I don't know how he's going to explain it, but if that comes in, that's not a co-conspirator statement. I don't believe, and we'll argue that. But we need to have it identified. Everybody has talked to everybody for the 8 years.
Well, you see, Mr. Harvey, that's part of the state's, I guess, with the RICO statute and its applicability, that's one of the most powerful aspects of the statute.
Bingo, but it doesn't trump the 801D2E exclusion. It's got to show it's in the course of, in furtherance of the alleged conspiracy. So there are more hurdles than just saying, yo, it's a conspiracy. Everything everybody says comes in.
And
even Mr. Botts knows that.
Your Honor, we have a full motion on that.
CLEs.
Yeah, I guess.
Along with you, so that may be a problem.
And Your Honor, I would just like to say on behalf of Mr. Stillwell that we do believe that the ball is in the state's court, and they're the ones that decided to indict this case this way. If they want to try Mr. Stillwell by himself, we all these problems will be solved, but they have decided to put 28 people together, and it's very difficult to determine what statements by the other 27 people will be attempted. They'll attempt to implicate Mr. Stelwell with, and I think I speak for probably the rest of the defendants in that sentiment as well.
Okay, so.
And y'all, on behalf of Mr. Myrick, I would join in on what Mr. Shaw said.
I think Mr. Harvey said that unless you opted out, I'm going to assume it is that it'll apply to the rest of you, okay? All right, bless you.
Thank you, Judge.
All right.
We have Mr. Floyd here, Your Honor, for the Demurrer.
I see him. Okay, all right. So, but to the aspect of that, Ms. Rosenwasser, you will have to kind of distinguish out or those particular statements. I would tend to agree with Mr. Harvey about that. You're going to have to distinguish the 801 D or E issues, okay?
Yes, Your Honor, I'll communicate that request to trial team and get that information to everyone as soon as I can.
Yeah, so I mean, it'll just make things a lot easier.
Absolutely, Your Honor.
Okay, all right. And you'll prepare an order denying that the issues as it relates to the motions in limine to the jail calls as well as to the bond, correct?
Yes, Your Honor.
Okay, wonderful. All right, okay. Mr. Floyd, good to see you, sir.
Yes, Your Honor, good to see you.
Okay, we have an amended special in General Demurrer 1, this relates this to Mr. Farley, to dismiss count 1. There's an amended special in General Demurrer's 2, overt action jurisdiction. 3 pertains to overt action, insufficient specificity of vague terms. 4 is unindicted co-conspirators. 5 is insufficient nexus. 6 is distinguishing between overt and predicate acts. 7 is duplicative counts. And then related to that would be an amended motion to sever, an amended motion to sever. And then the amended motion to sever his trial.
There's also one to dismiss the RICO count. Ready on that if.
Yes, to dismiss the RICO count, yes. Is that the,
Constitutionality.
the constitutionality of it, yes. If you could deal with those, sir, that would be wonderful. Okay. Mr. Menendez, do you wish to have any further argument on, or do you want to stand on your brief and I can let Mr. Floyd respond, or?
A little bit of argument, Your Honor.
Okay, all right, go right ahead.
Thank you, Judge.
Go ahead, sir.
So the first one, Your Honor, is a general demurrer. And so as the court knows, a defendant can generally demurrer if they could admit the facts in the indictment, but not be guilty of the crime charged. But the way that the state has uniquely indicted this case leaves it open to an interpretation where Mr. Farley would not be guilty of count 1 because they won't have satisfied the element of having a pattern of racketeering, which is at least 2 acts of racketeering. So, Your Honor, the way this all really gets started is the state has put the indictment in 3 parts. They have part 1 where they talk about the conspiracy. And what's interesting here, Your Honor, is they list, and I don't know if Your Honor has the indictment.
I do, sir.
You do? Okay. They list out in part 1, they list these bullet points where they essentially list in all the possible ways they can commit racketeering activity. But, Your Honor, what's very interesting is if you look at the last 2 sentences of that paragraph, part 1, it says, in furtherance of the conspiracy, the defendants engaged in the activities enumerated herein. But it does not say what they mean by enumerated herein. And in Black's Law Dictionary, it even says that the word herein is inherently ambiguous. It can mean anything here in this document. And Your Honor, they later in part 3, after describing the enterprise in part 2, they part 3 say acts in furtherance of the conspiracy. So the interpretation that I submit to the court is that when they say in furtherance of the conspiracy, the defendants engaged in the activities enumerated herein under one general Demurrer interpretation, which of course is not the way that the state intended to write it, but it's a way that they left it open to interpretation. That herein means the acts in part 3. Because the sentence right after that says the objectives of the conspiracy included but were not limited to, and then it has a colon, and we can assume that the colon refers to the bullet points. But that way we can interpret that the bullet points are there only to articulate the objectives of the conspiracy, not as any predicate acts or acts of racketeering. So when they say herein, they could be referring to just part 3. And Your Honor, in the 1 through however many it is, 1 through 91 overt acts, Mr. Farley is only alleged to be part of a few of those, numbered 95, 103, 110, 120, 132, 141, 173, and 176. And then also very interesting, Your Honor, that first paragraph of part 3, it says, in furtherance of the conspiracy and to the effect its objectives and purposes, the defendants committed and caused to be committed, among others, the following overt acts, certain of which constitute acts of racketeering activity. So they've left open this ambiguity that of these 1 through 191 things, they're overt acts, all of them, but certain of them are acts of racketeering. So then, Your Honor, under my interpretation as a general demurrer, you can look at each one of those acts and see that only 2 of them actually articulate criminal behavior. Because 95 talks about lyrics of a video that he's not even rapping in. 103 talks about a video that he appears in, not criminal activity. 110, again, talks about a video with some lyrics. 120 talks about him posing on a social media with clothing that has the word slime on it. Again, not criminal, not an act of racketeering. 132, engaging in a conversation. Again, Judge, that's not an act of racketeering activity to engage in a conversation, although that's the one where Mr. Williams is alleged to have made some kind of comment. 141, they talk about him having a tattoo that says ESPN, every slime plays nasty, or Rock Crew, raised on Cleveland. Again, Your Honor, having tattoos is not an act of racketeering. 173 and 176, though, Your Honor, are where they do accuse Mr. Farley of murdering Mr. Drinks. But now we're left with this general demurrer. Certain acts are racketeering of this list. So let's interpret them as literally only the ones that say acts of racketeering, which one of them is murder, 173, 176. So if we interpret herein that way, and certain of which in the way I've said, we're left with just 173 and 176. But Your Honor, clearly those then allege the same exact thing. And I know the state's going to get up here and say, well, they're not the same exact thing because they satisfy different elements. But Your Honor, they, in their manner, which they didn't have to articulate, they say that the defendants caused the death of Shamel Drinks, an associate of a rival gang. So even in that predicate act that's not gang activity, they talk about it being gang activity, saying that it was an associate of a rival gang and that they shot him as an act of racketeering activity. And then again, we have the same murder of the same person on the same time as the same alleged supposed gang, and it's worded the same, Judge. It's slightly different, but in both cases, they're talking about gang activity and a murder. And so that's not a pattern. You can't say that those 2 acts of racketeering activity constitute a pattern because they're the same act. They're going to say, well, one is they act as part of a gang and one is the act itself. But when they articulate the act itself, they say an associate of a rival gang. So they're saying there's gang activity even in that count itself. So they've just messed up here, Judge. They've left open an ambiguity to a general demurrer where I have found an interpretation that Mr. Farley in this indictment is only being accused of one act of racketeering activity. And Your Honor will see that the definition of racketeering of conspiracy to commit racketeering activity is a pattern, and a pattern is defined as 2 or more acts, whereas they've only under my interpretation accuse Mr. Farley of one act of racketeering, which can't withstand a general demurrer. And so that's why it should be dismissed as a general demurrer for count one. And Your Honor, my relevant definitions are just, OCGA for the record 16-4-4, which talks about the pattern. OCGA 16-4-3, again, defines that there needs to be at least two acts of racketeering to constitute a pattern. I cite to Black's Law Dictionary where they concede the inherent ambiguity of the word herein. And then I cite to Meeks v. State and Johnson v. State as it talks about demurrers, Your Honor. So that's basically the argument of count one, is that there is an interpretation that I've just articulated where it leaves only 173 and 176, and that those are the same exact thing, even the murder, because it's alleged as gang activity in its manner, and that that leaves us with just one act, the alleged murder of Mr. Schmel Drinks as part of gang activity, and that's not a pattern, Your Honor, that's just one.
All right, sir, anything else?
No, Your Honor, I can answer. I know it's like a lot, but I can answer any questions that the court has about that.
No, I'm good. Thank you, Ms. Menez. All right.
Thank you, Your Honor.
All right, go ahead, Mr. Floyd.
Two versions of this argument. The short one is wrong, 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 and wrong. The longer one is slightly more detailed.
Let's go with the longer one.
I'll go with the longer one.
Because it might get reviewed at some point.
I understand.
All right, sir. Thank you.
This argument has nothing to do with the text of the statute. And it has nothing to do with the governing legal standards. There is no, I have found an interpretation standard, and there is no standard applicable to general demurrers that endorses or indulges strained or artificial interpretations. General demurrers are not favored, and they are not construed in favor of the defendant. That's the starting point. So that the foundation is wrong. Specifically turning to RICO, it would behoove Mr. Farley to read the indictment as carefully and the statute, to read the statute as carefully as he reads the indictment. First, 1614-4C1 is the conspiracy provision. It does not use the term racketeering activity. It does not use the term pattern of racketeering activity. Okay, Mr. Menez is absolutely dead wrong when he says a pattern is an element of a conspiracy violation. The law is precisely to the opposite, and we cited the law in our brief. It is absolutely clear that a substantive violation is not a prerequisite to a conspiracy violation. If it was, the conspiracy violation would collapse into the substantive violation. It would become meaningless. And that would violate the most fundamental rule of statutory construction, which is the court does not read so much as a word, much less an entire subpart of the statute, to have no meaning whatsoever. Okay. The fundamental component, of a substantive violation is a pattern of racketeering activity. That's an A violation, that's a B violation. That is not what the state alleged. The state alleged a C violation. The C violation requires an overt act in furtherance of the conspiracy. It does not require a pattern of racketeering activity. Point one. Point two, he argues that overt acts must be acts of racketeering activity. No, same mistake. There is no reference to acts of racketeering activity in C. The case law is clear that acts of racketeering activity are not what are required. And as a foreshadowing to some of the other arguments that are going to be made, there are overt acts, 191 overt acts alleged. A subset of those, it's about 70, within give or take a couple, are acts of racketeering activity. They fall within the definition. Every single time the state alleges an overt act that is also an act of racketeering activity, it has said so. It has said an overt act that is also an act of racketeering activity, and it has said the exact incorporating provision from RICO that incorporates that underlying offense. Right? So we have drawn that distinction, but the point is both are good enough. And the first fundamental component of Mr. Farley's argument is we have to allege a pattern. That is wrong. The second fundamental argument is any overt acts we allege must be acts of racketeering activity. Equally wrong. The third argument that he alleges is that, or that he asserts, is that there has to be an overt act, he says, consisting of a pattern. We've already taken care of that one. But that there has to be an overt act by Mr. Farley. Again, equally wrong. Overt act can be by any conspirator. That's exactly what the statute says. And that any conspirator commit an overt act in furtherance of the conspiracy. Pasha v. State, which we've cited, makes this point perfectly clear. So does Whaley v. State, which we've also cited. As Whaley said, it has the basic principle of conspiracy, which we've talked about in various motions during the course of this, but Pasha says that each actor in a conspiracy is responsible for the overt actions undertaken by all the other co-conspirators in furtherance of the conspiracy. Those 191 overt acts, those are all Mr. Farley's in a conspiracy case, okay? Whaley says the same thing. A conspirator is responsible for his own racketeering activity and that of his co-conspirators. Whaley went on to say, this means that everything said, written, or done by any of the conspirators in execution or furtherance of the common purpose is deemed to have been said, done, or written by each of them. So this parsing that Mr. Farley's trying to engage into fails at its inception. He got the wrong requirement when he says pattern. He's got the wrong requirement when he says racketeering activity. And he's got the wrong requirement when he says it all has to be engaged in by Mr. Farley. This case would survive General Demurrer if you wiped out every single overt act specifically alleged to have been committed by Mr. Farley. It would still survive General Demurrer because he could not admit the allegations and still be innocent. For that reason, the General Demurrer should be overruled.
Your Honor, I think
What about the issue of the special Demurrer?
Well, he hasn't, at least here, asserted any argument. He began by saying this is a General Demurrer, and he hasn't asserted an argument relative to the special Demurrer. If he had, it wouldn't work for the reason that the indictment is very detailed. You know, one of the things that sort of becomes a hallmark of cases like this is that one defendant gets up and complains about how long the indictment is, and the next defendant gets up and complains that the indictment doesn't have enough detail about him. But you know, we've set forth the standard for special demurrers in the brief. Sanders v. State, a 2022 Supreme Court decision, says that, and it basically says, while Sanders may desire greater detail about how the conspiracy resulted in Singletary's death, it is not required that the indictment give every detail of the crime. A pause, because I'm not quoting anymore. That is particularly true in a conspiracy case where the state is not required to allege the details of overts and where the overts need not be crimes themselves. They can actually be lawful acts as long as they promote the objective of the conspiracy. Here we have many that are unlawful and constitute racketeering activity. We have others that are unlawful but are not within the definition of racketeering activity. And then we have a third category that are just overts. All of those can be found within the 191. But as Sanders went on to say, instead, the additional detail desired by Sanders may be supplemented by the pretrial discovery he receives and any investigation counsel conducts. Every detail need not be in it. They have to be sufficient to assert a plea of former jeopardy and sufficient to be able to defend. The Supreme Court dealt with this in Kimbrough. This is an argument that's coming in a couple more motions about the Nexus argument. The Supreme Court basically said, you don't need to plead everything. We don't need pages and pages. We're not requiring pages and pages. You just have to have something. We have a lot more than that something here. We have dates, names, places, names of victims, It is set forth in a chronological order where there are multiple actors involved in the overt act. We have alleged who those people are by name. That is more than sufficient details to survive a special demurrer, Your Honor.
Okay, all right. I'll pause just a second, and I'll let you come back up and argue the motion to sever the counts, and then his motion to sever his defendant, and then constitutionality, okay?
Okay.
Okay.
You want to come back to the other demurrers?
Yeah, just, unless you want to address them right now.
It's, Your Honor, I'm at your pleasure.
Yeah, that was only Demurrer 1. I titled it amended special and general because that's my original consolidated motions, but that was amended as just a general Demurrer, and I didn't even argue 2 through 7. But I do want to address his arguments about this general.
And Judge, just one moment. Please, we have our own demurrers, but these counts relate to Mr. Nichols, Mr. Stillwell, as well, and the overlap. So I want to adopt, at least insofar as an argument is concerned, some of them relate to, specifically to Mr. Farley, but to the content of the indictment itself. I would reserve my right to respectfully disagree with Mr. Floyd in what he has said, because they have pled, by the way, a pattern of racketeering activity. And if that ain't what they mean, then they shouldn't have pled it, number one. Number two, conspiracy is a specific intent crime. You have to specifically intend to commit the underlying predicate felony, which includes a pattern of racketeering activity. You have to have that specific intent. So I want to adopt and reserve, because some of these things relate specifically to Mr. Farley.
Thank you, Mr. Harvey.
On behalf of Mr. Stillwell, I too would like to adopt and echo the sentiments of Mr. Harvey and Mr. Nichols.
Your Honor, I don't think you're inviting argument on those motions separately, but I can address it if you want. But I'll just point out that if we have in fact pled a pattern, that's the end of that motion.
And Your Honor, it's just not.
No.
Yeah.
You pled the fact that the conspiracy was they did unlawfully conspire to acquire and maintain directly and indirectly through a pattern of racketeering activity. That's what the indictment says. You've pled it. And if it doesn't contain that, you're wrong about saying we don't need to put it in there.
And yes, Your Honor.
Mr. Floyd, you want to, okay, since they started to have multiple streams of arguments, you want to respond to that?
I'll do it however you want.
Okay, sir, go ahead and respond to Mr. Harvey's assertion.
Okay. We're being quoted out of context. The objective of the conspiracy entails the commission of a pattern of racketeering activity. Alleging that a pattern of racketeering activity was actually committed is not an element of a RICO conspiracy. The offense is the agreement as opposed to the pattern. That's why there is not a reference to a pattern of racketeering activity in C1. Mr. Harvey's just mistaken on that point. And the specific intent, there is no separate specific intent requirement for a RICO conspiracy other than the agreement itself. That's it. There's not an underlying second layer of intent to commit a predicate act. It's just not a requirement.
It's not.
Conspiracy is definitionally a specific intent crime because you have to have the specific intent to agree to commit the underlying alleged act. It is not a general intent crime. Conspiracy to commit a crime is a specific intent crime. So, and I know I'm a little bit out of order, and Mr. Floyd is way smarter than I'll ever be. But I just want to reserve my right to argue, to maintain the argument and adopt his argument.
And I'm fine if he reserves, Your Honor. I'd like the opportunity to respond in full too.
That would be
because this is not part of Mr. Menendez's motion.
You're correct.
And Your Honor,
Mr. Floyd, do you want to go ahead and finish his, because he's got like 7 of them. He's got this, 1 is dismiss count 1, 2 is overt action jurisdiction, 3 is overt action insufficient specificity in vague terms, 4 is unindicted co-conspirators, 5 is insufficient nexus, 6 is distinguished between overt action predicate acts, and 7 is duplicative counts.
And the way we've allocated responsibility for these, Your Honor, 1 through 6 are mine, as well as severance and constitutionality. And I'm at the court's pleasure. If we want to go through them all right now, I'm ready.
Yeah, let me let you finish those and then let him address if he's got anything more. So Mr. Mendez, let him finish, okay?
well, Your Honor, I never made my arguments about 2 through 6 yet.
I thought you did.
No, Judge, that was all just number 1. And I want to address some of his misstatements about number 1 as well just now.
Okay.
Before the court rules. So Mr. Harvey is right about that specific intent, first of all, but let's back up.
Okay, but let's not get too far down the weeds.
No, I know, Your Honor.
All right. In specific intent is they're inchoate crimes, okay?
Right.
All right, so yes, you do have to prove, there are specific intent crimes, but that's an issue of proof.
Right, Judge.
Okay.
And so to back up, though, to several things that were wrong about what he said. So look, he says there is no, I have found an interpretation about general demurrers, when that's exactly what a general demurrer is. If you can interpret the indictment in a way that the person has not committed a crime, meaning they have not committed all the essential elements of the count, then that's what a general demurrer is. So that's just a bit of gaslighting, a bit of, oh, if I just say it confidently and say it in a cool way, then I'm right. No, he's not. He's there. That's exactly what a general demurrer is. When there's an interpretation of the indictment that the person's not guilty and has not satisfied all the elements, it has to be dismissed. And that's exactly the interpretation that I presented to the court. And then Mr. Floyd tries to get up here and misread the statute talking about, oh, we did it under subsection C. Yeah, I know that. That's why I filed the motion. Subsection C, Your Honor, says it shall be unlawful for any person to conspire or endeavor to violate any of the provisions of subsection A or B. A or B. You need at least one of them, and he's going to come up here and say, oh, we only needed C. Well, you need at least A or B in both of the ways that someone can commit C. And then they have these 2 ways. A person violates this subsection C when either one of these 2 happen. He or she, together with one or more person, conspires to violate any of the provisions of subsection A or B. So you do have to violate subsection A or B to violate subsection C. So how can he come up here and say that? Or let's look at the other way then. Number 2, subsection C2. He or she endeavors to violate any of the provisions of subsection A or B of this code section. And both A and B have the word pattern in it, and pattern is defined in the statute as 2 or more, and they've only alleged 1 against Mr. Farley. And so the way this indictment can be interpreted is dismissed by general demurrer. And just because they can present the court with their interpretation, that's not enough. They need an indictment that is perfect in form within its 4 corners and that someone can't admit the facts to under any interpretation of innocence. And they haven't done that here, Judge. They've alleged it the way they alleged it, and that's on them. And as it pertains to just Mr. Farley, because only 2 of those acts are actual acts of racketeering alleged, and they're both the same act, that's why it's dismissed by a general demurrer. And that's why I put it as number 1, because we shouldn't have to argue 2 through 6 anymore, because number 1 is just, as far as it pertains to Mr. Farley, dismissed by a general demurrer by the exact way that Mr. Floyd said not to interpret it. Because yes, there's an interpretation where he's only being accused of 1 act of racketeering. And yes, under subsection C, you need a pattern. He tried to come here and say you don't need a pattern in subsection C. And that's just not true, because I just read the whole code section to this court, Your Honor. And in both ways you can commit C, it says either A or B has to be violated. And in both A and B, the word pattern of racketeering activity is included, Your Honor. So that's why for Mr. Farley, this general demurrer should be granted. And so I can go on to the rest of my demurrers, but I'll wait the court's ruling on the first one to see if we even need to go there.
All right, go ahead.
4 cases, Your Honor. United States v. Brown, 11th Circuit, 2007. Defendant may violate RICO's conspiracy provision even if he did not commit a substantive violation of RICO. United States v. Alonzo, 11th Circuit, 1984. Defendant may be guilty of a RICO conspiracy violation even if he did not commit the substantive acts that would constitute violations of subsections A or B. United States v. Salinas, Supreme Court of the United States. Defendant can be guilty of violating RICO conspiracy without violating a substantive provision. Cotman versus State, one of the APS cases, defendant was found guilty of RICO conspiracy without proof of a substantive violation of A or B.
And Your Honor, can is different than shall. Yeah, you can, but not with this one because of the way they wrote it.
Okay. I'm going to deny your motion, Mr. Menez, as it pertains to dismissal of count 1. You have any other further argument on overt acts?
Yes, Judge.
All right, let's go.
A second demurrer is a special demurrer. Sorry, Your Honor. The second one has to do with a jurisdictional argument. Because, Your Honor, if you follow some of the same things I articulated first about the indictment, you see that there are, in Part 3, certain overt acts that I believe under actually general demurrer need to be dismissed against Mr. Farley because they don't allege where exactly it was committed. They talk about released on social media. They say appear in a YouTube video. Well, Your Honor, YouTube is not a place. They didn't say that anyone in Georgia, because the Georgia RICO statute needs acts in Georgia. So all these social media ones that they have about Mr. Farley, for example, number 95, it says he appeared in a video released on social media. They didn't say that the video was made in Georgia. They didn't say that anyone in Georgia saw it. They just said that it was released on social media. And same thing with 103, Your Honor. They say that he appeared in a YouTube video. They don't say a YouTube video in Georgia. They don't say that anyone in Georgia saw the video. And so, Your Honor, that's the same for 110, 120, 132, and 141. 132 is a little different. It talks about engaging the conversation. But again, Your Honor, they say that Mr. Farley engaged in a conversation, which, by the way, is actually his clothing Instagram account as part of like a massive group message, and he doesn't even respond to it. So I don't know how that's engaging in a conversation with Mr. Williams. That's not how I define engaging in a conversation, but I'll move on from that, Judge. Regardless, it doesn't say where that conversation took place. Instagram is not a place. Instagram is not in Georgia. So they should have alleged that these people were in Georgia when they engaged in this conversation. Again, Your Honor, number 141, a photo released on social media displaying tattoos. Does not say those tattoos were seen on social media by anyone in Georgia, or that he's ever been in Georgia, or that those tattoos were made in Georgia. And we don't get to consider everything we know. For general demurrer, we look at just the 4 corners of the indictment. So, Your Honor, going to my authority and argument part, there's federal case law about this, Your Honor. It's Butte Mining, which is 76 F3D 287 291. That's out of the 9th Circuit.
How about the 11th Circuit or United States Supreme Court? That would be more persuasive to me.
Well, Your Honor, yeah, I'm using the interpretation of the federal statute.
Georgia, though.
Right.
Do you have any 11th Circuit interpretation on that?
That's not been addressed by the 11th Circuit, Your Honor. This happened with a case about RICO.
Addressed by our Supreme Court?
No, Your Honor. What I'm saying is that the Georgia statute exactly tracks the federal statute, and the federal statute's been interpreted to mean that those acts have to be in the jurisdiction of the court. Those are the cases I was going to bring up, where in Butte Mining and the Sonaltrino, those acts were alleged possibly in foreign jurisdictions, and that basically what I've articulated from Part 3 also might have taken place outside the state of Georgia. So I don't think that needs the 11th Circuit. That's just, this is how federal RICO is interpreted. So why would we interpret Georgia RICO any different when it's tracked and written exactly the same way. And so, Your Honor, in those cases, the demurrers were granted because the Ninth Circuit held that the defendant's conduct in the United States, by use of the mail and the wires, paying a fair price for the mining company, forming corporations, that those didn't actually refer to the fraud, and that the actual fraudulent acts took place entirely outside the United States. And so here, there's an open interpretation that these acts, putting something on YouTube, appearing on social media, engaging in conversation, those acts could have occurred outside of Georgia, and nothing specifically alleges them to have occurred inside Georgia. And so,
Doesn't the state have to prove that anyways as to each count by indirect or direct evidence?
at trial to meet their burden of overcoming the presumption of innocence, but he's also entitled to a perfect indictment within the four corners, regardless of looking at discovery or.
I don't think the indictment, the count requires that specifically that, because that's the state's burden of proof at trial.
Well, Roger.
It's implicit within each count that venue's got to be proven. It doesn't have to necessarily be pled.
And Your Honor, in those federal RICO cases, that wasn't enough to survive the general demurrer because of the way it was pleaded in the indictment.
Okay.
And so that's what I'm alleging here. And so because those acts can have occurred outside the jurisdiction, they can't survive general demurrer. So those.
But we don't know if they have occurred outside the jurisdiction, do we?
Right, Your Honor. We would have known that had they said appeared in a YouTube video seen by people in Georgia. It would be that simple, but they didn't do that. So that's why those overt acts, Your Honor, and there is case law about demurrers applying to actually individual overt acts as well, not just the entire conspiracy. And I have that, Your Honor, in my motion as well. That's Ralston v. Cox. They talked about
Okay, that seems
that
seems to occur. You seem to be arguing overt acts in jurisdiction and insufficient specificity and vague terms. Is that what you're kind of?
That's the next one, Judge. I'm still on the second one, which is the jurisdictional argument about those overt acts. Because Ralston v. Cox, you can actually demur to the overt acts, because in that case, the lower court sustained the demurrer to counts 2 and 3 and to the overt act number 3 of count 1. So I included that just to say that this court, it has the authority to address demurrers based on just the overt act. It doesn't have to be the entire count. So that's what I'm asking the court to do. Because the court has denied my previous demurrer, I'm asking the court to narrow down the indictment to take out these, what I believe are general demurrable things because of the jurisdiction argument. And so those overt acts, because they can be committed outside of Georgia, just don't survive general demurrer. And that's much different than, I understand what Your Honor is saying about they don't have to prove venue. Like they don't have to say in the exact count 55, murder Schmel drinks in Georgia, but the entire indictment talks about, this is a Georgia conspiracy. But just like in Butte Mining and the Coca-Cola case and the Sunel Trail cases that I cited, in those cases, it was a federal United States conspiracy, but those, overt acts that were outside the jurisdiction possibly could not survive general demurrer, Your Honor. So that's what I'm asking here. It would have been simple to just say what exactly the overt act is doing, because in the other ones, like when you say murder Schmel drinks, we can assume that happened in Georgia because it says honor about in this and that. But it doesn't say that the YouTube video was seen by anyone outside Georgia. That's the problem that's missing, Your Honor. And it doesn't allege that it was created in Georgia. The act they're alleging is appearing on social media. And so that's what I contend to this court, is that you can appear on social media outside the jurisdiction. And that would have easily been solved if they would have just wrote seen by people in Georgia. I think, it's like a tree falling in the forest type of thing. Like you can allege that he appeared on it, but then you also have to allege that it was seen. Otherwise, it's not an overt act.
Thank you. Mr. Floyd?
Yes, briefly, Your Honor. I am at a loss for this. It has to be seen argument. I literally, Mr. Farley is basically coming up with every requirement you can possibly think of and throwing them out. as though they're in the statute or they're in a case. They're not. The reference to the Cox case, Cox is a former Fifth Circuit case from 1941, 29 years before the federal statute was enacted, 39 years before the Georgia statute was enacted. Whatever else, and a civil case at that, whatever else it has to do with, it doesn't have anything to do with the Demurrer to Georgia RICO. Most of the cases he cites are civil cases, not criminal cases. Different standards of pleading. The indictment on page 12 alleges that the crime took place in Fulton County, Georgia. Just to begin with, it's right there. Second, the text of OCGA 1614.3 sub 5, which is the definition of racketeering activity, makes it abundantly clear that acts committed outside Georgia, and in fact outside the United States, can be acts of racketeering activity or overt acts for purposes of Georgia RICO. It incorporates 3 categories of conduct. The first category we don't have to spend a lot of time on because those are specific violations of Georgia law, right? And that's the overwhelming majority of what we're talking about here. Second, it incorporates the full definition, the entire definition of racketeering activity from federal RICO. So those are all federal offenses that can occur any place in the United States or any place in the extraterritorial jurisdiction of the United States. For example, one of those offenses is killing a United States citizen outside the territory of the United States because they're a United States citizen. So by its nature, it couldn't even happen within U.S. territory. It's still an act of racketeering activity, right? And then just in case there was any doubt, there's a category of 12 generic acts: murder, arson, kidnapping, obstruction of justice are a few examples that are in violation of federal law, the law of any state, or the law of any United States territory, punishable by more than 1 year in prison. So the intent of the General Assembly to incorporate such activity is very clear. We're not talking about things that happen outside the state of Georgia anyway. We didn't allege they happened outside the state of Georgia, but if they did, it wouldn't make a difference. On top of that, there's the Overton case, which we cited in our brief, which is not mentioned by Mr. Farley. Overton is a Georgia RICO conspiracy case out of Richmond County where a significant part of the racketeering activity that occurred in the state of South Carolina. Obviously, we all know Augusta's on the Savannah River. There was a kidnapping on the Georgia side. The victim, unfortunately, was transported across to the South Carolina side. He was locked in the trunk. The car was set on fire. He died. Okay. Act of kidnapping, Georgia. Act of murder, South Carolina. Both in the indictment, both supported the conviction. Both are specifically cited by the Georgia Court of Appeals in response to the sufficiency of the evidence challenge. Really, Mr. Farley is arguing what the probata has to be, not the allegata. He's talking, as you mentioned, he's talking about what we ultimately have to prove at trial to carry our burden. He's not talking really about what we have to allege. But the sense that there is some possibility that an act occurred outside the state of Georgia because the state did not specifically allege that it occurred inside the state of Georgia, I don't know how that has any impact at all in a conspiracy case where the state has alleged the conspiracy violation occurred here. And the argument that anything that happens outside the state is automatically excluded simply does not fit with the statutory text.
All right. As it pertains to special and general murder, 2 overt acts in jurisdiction, this court will deny the defendant's motion. All right, Mr. Menendez, number 3, overt acts and insufficient specificity of vague terms.
Yes, Judge. This is a just special Demurrer as to several parts of the indictment. I'm referring again to part 3, the only overt acts that Mr. Farley's alleged to be in out of 191. That's number 95, 103, 110, 120, 132, and 141. Those are the ones I'm talking about here. Your Honor, here, the court's actually pretty clear. I mean, the Sarajewski case, held that that indictment was deficient and that it lacked any description of what was alleged to be threatening communication. So here in this motion, Your Honor, I'm shifting our focus to these vague terms that they're putting in the indictment that Mr. Farley is entitled to be more specific so that he can be prepared to defend himself at trial, because he is entitled to an indictment perfect in form within its four corners. And the key thing here, Your Honor, under Sarajewski is that it needs to be sufficient so that he can avail himself of a defense, to prepare himself for a defense. He's not given enough intelligence here about what he's even going to be fighting. So just like when Sarajewski dismissed that count for threatening communication or endeavor to impede, that's what I'm arguing here, Your Honor. There's also the Delaby case that didn't survive a special demurrer. That had the term intimidation being insufficiently specific. So, Your Honor, each of these overt acts, except for 173 and 176, do contain terms that are so vague that we can't possibly prepare our defense intelligently within the four corners of the indictment, Your Honor. And he can't be sufficiently apprised of what he's going to be prepared to meet at trial. 173 and 176, I do concede, okay, those are specific enough. It talks about shooting a person with a gun. That shooting with a gun, that can't be committed in any other kind of way. But importantly, Your Honor, the Delaby court holds that the term intimidation was impermissibly vague because intimidation can be, committed in so many different ways. And again, Your Honor, despite its age, Ralston v. Cox is still good law. It's an example where the court has the authority to demur specific overt acts of conspiracies, not just whole conspiracy. And so, Your Honor, now I want to go to each of these acts and the allegations and how they're vague. So number 95, again, appearing in a video released on social media, doesn't say what that means. What do you mean appear in a video? And just the proof of what I'm saying, Your Honor, is the way it's been talked about at different points during this case in the proffers. Appear in a video, appearing doing what? Saying what? Rapping, dancing, what? It's just, that doesn't say like appear in a video, Your Honor. It doesn't say anything about how that's furthering the objectives of anything or what that even means, Your Honor. Same thing with number 103, that he appeared in a YouTube video titled Mob Ties and that the defendants were flashing gang signs with lyrics. He doesn't say, does he even say these lyrics? Does he mouth them? Did he write them? Does he rap them? What? It doesn't say, Your Honor. It just says he appeared in a YouTube video and then says defendants were flashing gang signs with lyrics. Which defendants? It should have said which ones. It should have said what they mean by appear. Should have said what they mean by the lyrics. What is the significance of the lyrics and Tupac and Hit 'Em Up? Doesn't say. Just says he appeared in there. Same thing with 110, Your Honor, a YouTube video of a song of Mr. Wunny Lee saying vaguely and sufficiently that he appeared in it. At first bond hearings, they tried to say like he was saying the lyrics or he has something to do with the lyrics. And while I don't think those lyrics are probative or have anything to do with reality, even so, he's not alleged to have written them, rapped them, mouthed them. I want to know, he needs to know what appear in a YouTube video means. And then they just say some lyrics. And Your Honor, now number 120, a photo released on social media that he posed for a photo. What does that mean, posed for a photo? How is that the overt act? What about posing in a photo and that it was released on social media? What is that? What is an overt act about releasing something on social media? Again, doesn't say anybody saw it and doesn't say what they mean by posed. So then go to 132, that he engaged in a conversation. This one really needs to be defined, Your Honor. Engage in a conversation, that's vague. What do you mean engage? Talking and talking back? Having your account that maybe you don't even manage get a message from other people that you don't respond to? Is that what they mean? That's what it is, but we need to look at it within the four corners, Your Honor. And so to say vaguely, oh, he engaged in a conversation and then say stuff that they allege Mr. Williams to have said, what is that? How do I defend against that? What does that even mean? Same for 141, Your Honor, posing for a photo. I already made those arguments for Act 110. So, Judge, those are the ones. They're all impermissibly vague. They each contain at least one vague term that needs to be further defined because it's not defined enough, just like in Delaby and just like in Sarajewski, where those things were not sufficiently defined. Here, I would argue to the court, we have terms that are even more vague than the terms in those courts which didn't withstand a special demurrer. And I know the state's going to cite the case law that, oh, we just have to track the language of the statute, but that's only the first part. It's a two-part analysis. They have to track the language of the statute, but they still have to sufficiently appraise the defendant of what he's going to be defending himself from. And these vague terms rob us of the chance to do that, Your Honor. And so that's why those overt acts should be dismissed by a special demurrer, because they are impermissibly vague.
All right, thank you, sir. All right, Mr. Floyd?
Yes, Your Honor.
First point is the state is not required to allege every overt act, and the state is not required to allege overt acts in great detail. That's the law. They are not separate counts. They are overt acts as part of an overarching count. And so the level of specificity which Mr. Farley is seeking is simply not required. I can only say it strikes me as feigned confusion here. As to each of these acts, the state has alleged the specific date. It has alleged everybody who's involved. It's not like he doesn't know what we're talking about. Okay. The individuals in almost every one of these acts that are referenced, other than Mr. Farley, are co-defendants. The idea that he is bewildered at what it means to appear in a video, to appear in a photograph, is simply an untenable argument. What does it mean to be released? Well, people talk about releasing videos, releasing movies, releasing all kind of TV shows, et cetera, all the time. Social media, not exactly a vague term. And numerous times we've mentioned the specific platform like YouTube. A conversation, again, not real confusing, particularly since we've quoted language from the specific conversation. And he has the videos. He has the photos. He has the transcripts and recordings of the conversations. And so under the standards that we've cited before, including Sanders versus State, that is more than sufficient. We're not talking about something where Mr. Farley wasn't present, and we're not talking about something that Mr. Farley hasn't received in discovery. We're not talking about something that's some grand mystery about what's going on. I've never seen a case that said this is demurrable, and I don't think this is going to be the first one. If Your Honor has any questions, I'd be happy to address them.
No, I don't.
Very briefly about that, discovery has nothing to do here. It's not feigned or not feigned. It's that you need to do the legal analysis and we need to put everything out of our mind except for the four corners of your head. Case law is very clear about that. So it doesn't matter that I've seen the videos. He's entitled to indictment perfect and form within its four corners to sufficiently appraise himself. So all that extra stuff is actually not part of the court's analysis. It needs to be restricted to the indictment itself only. Because we pretend for purposes of error that we don't know anything else except for the indictment. That's what it means.
Your Honor, Sanders versus State, unanimous decision, Georgia Supreme Court, 2022. The additional detail desired by Sanders may be supplemented by the pretrial discovery he receives any investigation or counsel conducts.
All right. I'm going to deny your motion in regards to General Demurrer, especially General Demurrer's 3 overt acts and insufficient specificity of vague terms. Let's move on to the issue involving unindicted co-conspirators, Mr. Menendez.
Okay, thank you, Judge. And the last 3 are actually very short and straightforward. I can probably get all 3.
That'd be fine. Okay. Unindicted co-conspirators, insufficient nexus, and distinguishment between overt and predicate acts.
Yes, Judge. Those are the same arguments under special demurrer that he's entitled to an indictment, perfect in form, that within its 4 corners puts him on notice of what he's going to defend himself against. The way that fails in this regard is that they just say in the indictment that Mr. Farley and the other co-defendants, together with unindicted co-conspirators, did these things. Well, for the indictment to be perfect in substance and form within its four corners, they need to say who those unindicted co-conspirators are. So that is the substance of this motion, Your Honor, merely that it doesn't withstand a special demurrer because it includes these unindicted co-conspirators without telling us anything about them or who they are. So that's that one. Number 5, Your Honor, it's just an insufficient nexus because under Schiffels v. Kemper Financial Services, which again, yeah, it's a civil case, but that's something unique about RICO is that it does have a civil component and a criminal one. And there's no difference in how those are decided. There's a difference at trial of what their burden is, either preponderance or beyond reasonable doubt. But as far as demurrers, there is no difference. And there is a civil application of RICO. And in that application, Schiffels v. Kemper Financial Services, they say that to allege a conspiracy to violate Georgia RICO, the state would have to plead that each defendant knowingly agreed to conduct the affairs of a particular enterprise and that each conspirator agreed to the commission of the predicate acts and that each defendant knew that those predicate acts were part of a pattern of racketeering. So how can I do that when I don't know who these supposed unindicted co-conspirators are? So, Your Honor, again, under Schiffels, it says conclusory allegations of conspiracy are not sufficient to allege a criminal act under OCGA 16-4-14 and 16-14-8. Rather, the state must allege facts from which one can infer each defendant's agreement to violate the laws the state contends constitute the racketeering activity. So, Your Honor, for those reasons, it can't survive a special demurrer to have an indictment that says, oh, together with unindicted co-conspirators, because then how are you on notice of how to defend yourself? How are you on notice about what attorney you want to hire, whether you want to make a plea, when you don't know whether that specific intent is going to be satisfied? You don't know who these unindicted co-conspirators are. That's a pretty simple thing, Your Honor. I think that line, unindicted co-conspirators, either needs to be removed or needs to be reindicted to tell us who those unindicted co-conspirators are. As far as insufficient nexus, Your Honor, that's the one I was just talking about before that the allegations need to allege facts to infer that each defendant's agreement to violate the laws. That was actually, I was talking about the nexus, Judge, my bad. There, they don't allege that, Your Honor. So the nexus between the enterprise and the conspiracy is insufficient by this indictment. And then lastly, Your Honor, they say overt and predicate acts, the part that I referred to in count 1, where they say that some of these, certain of which are acts of racketeering, that's again not acceptable under a special demurrer. They need to say which are the overt acts and which are the predicate acts. They can't just list them and then say certain of these are acts of racketeering. They need to say these are the acts of racketeering, these are the overt acts that aren't. Because otherwise, how do I know which one they mean is which? So those 3, Judge, insufficient nexus, that applies to the entire count 1. But as far as the distinguishing between overt and predicate acts and unindicted co-conspirators, that's just something that also needs to be included, Your Honor.
All right, sir. Mr. Floyd?
Yes, Your Honor.
So we have unindicted co-conspirators, insufficient nexus, and distinguishment between overt and predicate acts.
Yes, sir.
And then we'll move on. I think there's, Mr. Menendez, you haven't dealt with duplicative counts.
Oh, Your Honor, I think Mr. Floyd said a different colleague of his was gonna-
I'll handle that response, Your Honor.
Okay, all right, okay.
Okay.
All right.
So on number 4, Your Honor, unindicted co-conspirators, no case cited by Mr. Farley that says we're required to identify those and kind of misses the fact that they are unindicted. And there's a problem with identifying individuals who are unindicted in an indictment because they don't have the ability to come in and demur or otherwise seek relief. Their reputation can be devastated, but they don't have standing to come in and do that. That is why it presents, I can't say it never happens, but that is why the state and also the federal government are very reluctant to do that. And you see things like unindicted co-conspirator A or unindicted co-conspirator 1 referred to in indictments because that person doesn't have a chance to come in and respond. They're not a party. There are some jurisdictions that suggest it may be unethical to do so. That's not a universal rule, it's a practice, but it makes sense. Second, we've identified all unindicted co-conspirators who are known to us in discovery. We haven't held anything back on that. As far as insufficient nexus, the case is charged in the language of the statute, and it specifically references the nexus. And all nexus is a connection. There has to be some kind of relationship. Kimbrough is the controlling case on this, unanimous Georgia Supreme Court case written by Justice Peterson. And it basically says it doesn't take much and gives a number of examples. We have specifically alleged they conspired to associate together and with others for the common purposes of illegally obtaining money and property through a pattern of racketeering activity and conducting and participating in the enterprise through a pattern of racketeering activity. That's exactly what a nexus is. And that is more than sufficient under Kimbrough. We then go on to give specific examples of what was done, such as preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, including murder, assault, and threats of violence. That money, weapons, and other property were obtained through acts of racketeering activity, including robbery, theft, and the unlawful sale and distribution of drugs. We also allege that persons who were involved in the conspiracy to participate in and conduct the enterprise obstructed law enforcement investigations and court proceedings through witness intimidation and attacks upon law enforcement officers. That's drawing the connection between the conduct and the enterprise. That is all that is required. Distinguishing between overt acts and predicate acts, we did. I mean, we did exactly what Mr. Farley claims we didn't do, and it's right in the indictment. It's a key dramatic moment when the screen went dead black on me just as I picked it up. Your Honor, I'll just start with Act 1, and I'll blessedly stop with Act 1 because there's 191 of them. But in that case, we talk about aggravated assault with a deadly weapon, a firearm against the person of Reginald Pettis. Go through the allegation. In violation of Georgia law pursuant to 16-521, which is an act of racketeering activity under OCGA 16-4-3 sub 5A little v, and an overt act in furtherance of the conspiracy. Where it is both, we say exactly that. We do it over 70 times. Where it is only an overt act, we do not make the reference to the underlying incorporating provision from RICO. An example of that is number 7, which involves Mr. Murphy. We consistently did that throughout the indictment. That's exactly what he's complaining of. The thing he says is missing is there.
Okay.
That's all I have right now, Your Honor.
All right, sir. In terms of,
Tag along to the first part of that with the unindicted co-conspirators, not the other ones, but I do have a similarly situated motion with regard to the identity of unindicted co-conspirators. In the indictment does say the defendant conspired to associate together and with others. Doesn't say who the others are, and we can argue this at a separate time. I have no problem with that, but I do want to say, in contradiction to what Mr. Floyd said, that we routinely file motions for the names and identities of unindicted co-conspirators. They may not be put in the indictment, but we routinely are provided with a list of unindicted co-conspirators because we all are entitled to know who we have conspired with, number one, and whose statements may or may not be able to be used against us under 801 D2E. So I just want to tag in on that one.
all right, thank you, sir. All right, based upon the arguments and applicable case law, I'm going to deny defendants unindicted, amended special and general demurrers 4 unindicted co-conspirators. I'm going to deny insufficient nexus. That's general demurrers, special demurrers 5. I'm going to deny distinguishment between overt and predicate acts. And I think that gets us to the duplicative counts in terms of general and special demurrers, as well as the motion to sever counts, motion to sever the trial of defendant, motion to declare the Georgia gang statute and corresponding rule of evidence 418 unconstitutional, and the Georgia RICO statute unconstitutional.
And Your Honor, I was wondering, I know we're getting late into the day. I'm going to be here all day, all week. So if the court would like to.
2 shows daily.
Here's the one I'm doing tomorrow, and just hear Mr. Floyd's. That's as amenable to me or the court.
Okay, Mr. Floyd, what else are you arguing, sir?
I've got severance and constitutionality, Your Honor.
All right, let's go ahead and roll those up at this point in time, and then I can, is that the only other two that Ms. Rosen wants to handle the rest?
I believe the only, I think it's those, and then I'm handling the one about the duplicative. And
Yes.
I'm sure I can.
We'll push that till tomorrow along with the other ones related as it relates to you. But just so we handle the ones involving Mr. Floyd this evening. So, sir, if you could go ahead and continue with that.
Okay. Well, I think Mr. Menendez may want to make his argument first.
All right.
Yes, I'm prepared to respond to both.
So you're going to do the motion to sever?
Yes, sir.
Okay. And that's just his, not the counts, just the severance, right?
I was going to do both.
Okay, you can do, okay, so that's,
Yes.
you'll do the motion to sever counts and the trial, and then the unconstitutionality of the gang statute?
RICO statute.
RICO statute, okay, all right.
And Your Honor, I can take the gang statute, or I believe Mr. Carlson was interested in that one, but if he's.
And 418, yeah, you can, okay, that's fine, that's fine. Okay, all right. Okay, Mr. Menendez, go ahead, sir.
Yes, thank you, Judge. As far as severing counts, what I'm asking here, Your Honor, for Mr. Farley is to sever his trial into count 1, the RICO count, and then another trial that has the other counts that he's alleged to be in, which is 49, 50, 51, and 54. So, Your Honor, Johnson states that pretty clearly that when 2 or more crimes of the same or general nature are committed against different persons at different times and places, and they're charged in separate counts of an indictment, severance is mandatory upon the defendant's motion if the crimes are joined solely because of their same or similar character. Your Honor, that's Johnson v. State, 364 Georgia Ave. 543. That's from 2022. It goes on to say that if the offenses are not joined solely because they're the same or similar character, and evidence of one charged offense would be admissible as a similar transaction during trial on another charged offense, the trial court's vested with discretion in deciding whether to grant the motion to sever. So there's nothing commanding Your Honor to do it one way or the other. But I am asking Your Honor to do that because the court does go on to say in that case that in making this decision, the court must consider the number of offenses, the complexity of the charges, that's crucial, and the complexity of the evidence, and determine whether a jury will be able to fairly and intelligently parse the evidence and apply the law. So here, Your Honor, we have a completely unfair trial as it counts to the murder counts, because here what we have, if you were tried just on the murder counts, we have a person who's an entrepreneur, networking, and finds himself riding in the backseat of a car that's behind another car, and then something happens where we don't know the circumstances. So, Your Honor, that's a very different kind of trial than me having to fight that on its own versus me having to fight that now with all these people and all these attorneys and all this evidence of RICO going back to 2013, 2015, wiretaps, all this stuff, just to simply decide whether sitting in the backseat of a car makes you a party to a murder when there's no other assistance alleged and he's merely present, merely associated. And so, Your Honor, to get up here and then you're going to tell the jury, oh, mere association doesn't count on these counts, but then here's a whole RICO case where the entire nature of the case is association, which is okay. I mean, I disagree with RICO, as we'll find out from our other motion, but to do a RICO count and then these murder counts together is just, not fair, Your Honor. And they are joined solely because they're the same and similar character. So that's that, Your Honor. I mean, there is nothing. There's the murder of Mr. Schmeldrinks, and then the jury's analysis of the burden of proof on that is going to be just completely confused by the complexity of the other case. And then it really is just this presence and this association that ties him into the RICO. So under Johnson, Your Honor, I'm just asking this court to sever count 1 from the rest of the counts just for Mr. Farley.
All right. Go ahead and argue the rest of the, that's your motion to sever counts. What about the trial? And then you can deal with the gang statute, your argument on the gang statute and the RICO statute.
Yes, Judge. So admittedly, this motion to sever the trials is a lot stronger. And I do think it's less discretionary and leads, if we don't sever it, to a situation where Mr. Farley's rights are just completely trashed. So, for example, the biggest reason, Your Honor, is because there's so much evidence admitted against one co-defendant that wouldn't be admitted against him. Okay, but what I think is the strongest argument, Your Honor, is just the scale of this. We've had all these pretrial hearings about how it's going to take 6 to 9 months. And so, Your Honor, to have a defendant like Mr. Farley, who doesn't have the resources like some of the other defendants, who we now see still don't have an attorney, Your Honor. So I think the proof is right behind me how difficult it is for someone to hire an attorney of their choosing, free of conflict, which is his right under the Sixth Amendment. He has a right under the Sixth Amendment to an attorney of his choosing, free of conflict. Had it not been for me agreeing to do the case, that would be impossible. And that's impossible for a lot of the co-defendants, Your Honor. We've seen that. When you try 28 people at once, you're like taking up all the private attorneys of the city that you live in, and you're asking that private attorney who has had to go through years of training, hundreds of thousands of dollars of education, and now these clients essentially rent us out for their advocacy. And that's just not fair, Your Honor. It's like, oh, you're going to go to the prom, we're going to rent you a limo, but now, oh, actually, this prom is going to last 6 to 9 months, and you're going to have to rent a limo every single day. You're going to have to rent out Mr. Menendez to sit there with you every day and pay him by the hour. That's not fair. It's not fair, Judge. So that will be solved by severing the trial of Mr. Farley. That might be fair to some other defendants who are all over the discovery, but Mr. Farley, he's only in like 7 out of the 191 overt acts, and he's only in 4 of the counts. So in that 6 to 9 months, my actual engagement in his advocacy will be a matter of days. It's something we can do in a week and a half. But what the state has done to rob him of his rights under the Sixth Amendment and his rights to due process and his right to be treated equally and not be discriminated against based on wealth or anything else, they've put 28 people together. And then for those people that are in such a small part of the discovery, they've created a situation where you don't get to pick your attorney. You just get to hope that you'll have someone agree to something, even though it might not make sense. And now look what we have. We have people who are still unable to hire an attorney. And I think part of it is because of this lack of severance. And so, Judge, to force Mr. Farley to sit there with a paid advocate who's not going to do anything for months at a time is not fair, Your Honor. They're essentially picking his attorney for him by saying, oh, you got to have this amount of money or otherwise you can't defend yourself, which is not fair because what he only needs is someone to defend him for a few weeks. And this RICO count, they could easily just prove just those overt acts and the existence of a conspiracy. It's not going to take a long time. They're going to say, oh, they're going to make us redo this RICO conspiracy over and over and over. No, they just got to show what they say is seemingly based on the rulings of my other motions. It's not that hard. A nexus, a few overt acts, a pattern, and that's it. That can be done with just a handful of witnesses in addition to his other counts, Judge, but that should be separate. That way it can be done in like a week and a half. And that way Mr. Farley isn't forced to defend himself in the way that he has to resort to because of money and because of this sort of wealth discrimination of accusing this many people at once of something, Your Honor. And so I included other arguments, of course, but those have been articulated by other co-defendants in the past. It's more just for the record. But I do cite some things like Morris v. State, whenever it appears necessary to determine a fair determination of the guilt or innocence of a defendant. To have a fair determination of that, Your Honor, Mr. Farley should have his trial severed so that it can be just a week and a half. And then he can have an attorney of his choosing, free of conflict, and he can have his due process and his confrontation under the Fifth and the Sixth Amendments.
Okay, let's move on to now the, your argument in terms of the gang statute, unconstitutionality, as well as the RICO statute.
Yes, which one do you want, Your Honor?
I'm
doing RICO, Ms. Rosenwasser is doing gang.
Okay, let's see then. I will table Ms. Rosenwasser's one till tomorrow. She's doing the gang statute? Madam, is that what you're doing? Okay, all right.
I'm sorry to interrupt.
That's okay. No, that's fine, sir. Okay, then you're doing unconstitutionality RICO.
Yes, sir.
All right, handle that for me, please. Let's do that tonight.
Yes, Judge. Things don't change until they get challenged. Our country has a long history of case law that then realizes, oh, this was wrong. And it just takes someone doing the right thing and challenging that for that determination to even go up to a higher court, Your Honor. So that's why I am objecting to these. Your Honor, just because something has been deemed constitutional in the past just doesn't mean that it is. And I think this case specifically.
What's your basis to have, for me as a trial judge in this case, to have it declared or the unconstitutional? It hasn't our Supreme Court already passed on this issue?
Not as it pertains to this exact set of facts. That's why this is distinguishable, Judge. One, the scope of it and the financial aspect, but also the First Amendment aspect. We have several overt acts here that involve artistry, just entrepreneurship, clothing, and that's an unconstitutional application of finding someone accountable criminally for something.
Well, I think the state's argument is when those acts, and this is what I guess we'll find out at trial, whether or not those acts are basically admissions. So
exactly, Your Honor.
So that's something we'll take up at trial.
Yes, Judge. And I of course, I don't expect the court to rule in my favor on this, but I do want to have it for the record. And you never know, this is a chance to do something cool. And I think it is the right thing, Your Honor. The vagueness as well of the RICO statute.
But you have to have a good faith basis to challenge the statute. So I think you've raised one. If you're saying that is the issue of the interplay between the First Amendment and clothing, some other things. Yes, that is fine.
Yeah.
And you certainly are well within your rights, and you wouldn't be a good advocate if you weren't doing that on behalf of your client, okay?
Yes, Judge. And just real quick for the record, the other things I put in my motion were the fact that they're able to put so much evidence in the indictment itself is unconstitutional. We don't get to do that for any other allegation. There's social media pictures in the indictment. Your Honor is going to read the indictment to the jury, and they're going to see actual evidence before they even get to the opening statements. That's not how it's supposed to work, Your Honor.
Well, I'm going to read it, but actually I'm going to tape it, so. And I don't plan on showing the picture, so.
Yes, Judge. And then lastly, we don't have any mechanism here like we do in civil law to have a motion for summary judgment, which is a type of thing I think would have been granted for Mr. Farley here, because not only is the indictment doesn't allege anything, the discovery itself and the warrant affidavit itself for his arrest simply alleges presence and association. So there's nothing stopping the state when they're out to get somebody, they can just in bad faith with a warrant that doesn't say anything about how you're a party, just loop you into a big RICO case and then start pressuring you to cooperate or take some kind of deal, because what else are you going to do? But there is no mechanism pre-trial to have Your Honor look at any of that. And so that's another aspect. Well, I can't suppress the whole case, Judge. I can only suppress.
I know, but as it pertains to your client, you filed some 23 motions. I think you're doing a fine job.
Well, thank you, Judge.
Okay. Anything else? Relates to unconstitutionality?
No, Your Honor, that's all.
Okay, all right. Thank you, sir. All right, Mr. Floyd.
Thank you,
I
Your
think
Honor.
he's got, a motion to sever the counts, sever the trial, and unconstitutionality of the RICO statute.
Yes,
And
Your
I'll
Honor.
table I'll let Ms. Rosenwasser tomorrow cover the duplicative count issue as well as the gang statute. And I think she said Mr. Carlson will come in and argue the evidence 418 issue.
Mhm.
Okay?
Yes.
Yes, sir. Ms. Johnson.
Response would just like to join in Mr. Menendez's motions with regards to the severance of the count and the trial.
That's fine. Okay, all right. And Mr. Floyd,
Yes, sir.
whatever the ruling is, can I ask you to prepare an order on whatever grounds, on the issues that I've denied, you prepare suitable.
1 through 6, the amended special general. Yes, sir.
All right,
Will do.
let me rule on these things first, and then I'll let you, depending how I rule on these, I may ask you to include these, okay?
Whatever the court's pleasure is,
Okay.
yes.
All right, sir.
So severance. Your Honor has already heard severance motions, I believe 7 of them.
I have.
You have already denied them all.
Yes.
I had a feeling you'd remember, but just in case, I wanted to remind you. The mistaken premise, and it's been true throughout them all and is true here, is the idea that somehow if you sever, the trial becomes much smaller, shorter, easier, a week or whatever. Unfortunately, it doesn't work that way. This is a conspiracy case. We're going to have to prove the enterprise. We're going to have to prove the overt acts, and the evidence is largely the same. I can't say it's exactly the same. I won't go that far, but it will be substantially the same in each circumstance. And so there's not that time efficiency that keeps getting rolled out in front of you simply doesn't exist. That's the primary reason why, and we've cited these cases previously, I haven't been able to find a reported Georgia RICO case where severance was granted and the issue came up on appeal. I just haven't seen it. Every one of them, the posture is severance has been denied. The court looks at it, the appellate court looks at it, says it's a matter of discretion, and discretion was appropriately exercised. And those cases are very similar to this one. We've also cited to you on the same principle an extensive number of federal RICO conspiracy cases. I'm dealing specifically with RICO conspiracy because the question is the same and the standard is essentially the same. The problems that we've mentioned in the past, inefficiency, the trauma of causing individuals to testify repeatedly to violent acts they've suffered, the opportunities for witnesses to shape their testimony in subsequent trials, all of those considerations, that's not the entire list, but we've briefed it extensively in the past. They don't go away. They would actually only get worse if Mr. Farley was to have 2 trials, one on RICO and one on murder, et cetera. That doesn't solve the problem. It really magnifies it. I think part of Mr. Farley's constitutional arguments drifted over into the severance side, or perhaps he feels they're applicable to both. It doesn't make any difference here because he was talking about Sixth Amendment issues. Mr. Farley has an attorney. And that's Mr. Menendez. Mr. Menendez has, as you pointed out, filed a very extensive list of motions on his behalf and is fighting for him as hard as he possibly can, as we would all expect him to do. So, but part of what comes with that is Mr. Farley doesn't have standing to raise constitutional issues relating to other people who don't have counsel for whatever reason. He can raise his own. He could raise it if he didn't have counsel, couldn't obtain it, but that's not the situation. And therefore, that's just not an argument that's available to him. As far as constitutionality is concerned, let me first address vagueness. There are quite literally hundreds of RICO challenges based on vagueness. None have succeeded. There are hundreds in the federal system. There's approximately a half dozen, I believe, in our system. And the counterpart state RICO statutes across the country, there's about another 35 or 36 of them. Many of those have been challenged. Vagueness has not worked once. Vagueness didn't work in the Rodriguez case against our gang statute either, for essentially the same reasons, because the statutes have a lot of similarities. There's nothing new here presented on vagueness that hasn't been addressed in the past. In fact, there's nothing really specific at all presented on vagueness. As to First Amendment, it just conflates the problem. The argument that keeps, or the statement that keeps getting presented to the court, is that speech has been criminalized. That's not what we're talking about. We are talking about speech as evidence. There's no offense that says somebody's not being charged with making an offensive lyric or video. That crime doesn't exist in Georgia. It is not alleged in this indictment. But the fact that somebody is engaged in some sort of performance doesn't immunize them and doesn't create a First Amendment shield against all responsibility. I've not been able to find a case that said that a charge is unconstitutional or a statute is unconstitutional because some sort of performance is involved. And frankly, that wouldn't be a basis to hold the statute unconstitutional. It would be a basis to exclude a specific piece of evidence. I imagine that's an argument we're going to get to pretty soon, but that's not a constitutional argument here. The United States Supreme Court in Wisconsin versus Mitchell made it absolutely clear that something doesn't stop being evidence because it's in a book or a movie or a poem or a song or a diary. Because that would lead us to the absurd circumstance in which a person who simply picked up the phone and called the police and said, I murdered John Smith. I did it in this place. I did it on this day. I did it for this reason. And I did it using this weapon. You can go find his body right now. Well, we pretty much know what's going to happen there, right? But if I post it on YouTube and I sing it, that becomes inadmissible. And if we use it to charge, the statute becomes unconstitutional. There's nothing, absolutely nothing that supports that. The too much evidence in the indictment, this is exactly what I was alluding to before, which is the argument that the sort of Goldilocks argument the state usually faces. It's either too much or it's too little. It's never just right. But, you know, this is the same defendant who 30 minutes ago was arguing that we hadn't given the dictionary definition of various phrases in it, and now says, but wait, this statute's unconstitutional because you can talk about too much. Those two things can't occupy the same place at the same time. As I said, I am not aware of any case anywhere in the country holding any RICO statute unconstitutional on any of these grounds. Don't think this should be the first one.
Okay. All right. As it pertains to the amended motion to sever counts, I'm going to deny that motion as it relates to Mr. Farley. I'm also going to deny the motion to sever his trial from the other co-defendants. And I'm also going to deny the motion to declare the Georgia RICO statute unconstitutional. So, Mr. Menendez, we will take up there's three things I think we'll take up tomorrow as it relates to Mr. Farley's duplicative counts and the unconstitutionality of the 418 and the gang statute tomorrow. So I'll take up those. I've otherwise, the other issues, as I've indicated, we'll table those until such time as, like for the autopsy photographs and the music video and social media evidence, okay?
Yes, Judge. And the evidentiary motions for 28th.
You got three, yeah, we will take up those on the 28th. Yes.
Yeah. Yes, Your Honor. Our witnesses would be available on the 28th. So
Yeah, but those are only the three for those three motions, right?
yes, Your Honor.
Okay, all right. So we'll take up those then. All right. In the waning hours of the day, let me just recap, Ms. Rosenwasser, for tomorrow. You've got Walter Pineda.
Yes, Your Honor, he'll be coming first.
You got Quentin Hall.
Yes, Your Honor.
Okay, do you have anybody else that potentially you might be able to move up or might be, depending upon how we go tomorrow?
Not to my knowledge, I'll reach out to Investigator Worrell tonight. He was one of the people on for Wednesday. I can see if he's available. But we do have Mr. Stillwell's motion to dismiss. We should be able to do that. I know the court wished to hear that tomorrow as well.
Okay, all right.
And then obviously I'll be ready for Mr. Farley's motions also. The two that we just talked about.
All right, I think that's plenty. And then there'll be some, I'm sure that, folks, just to put you on notice, Thursday, we will have to take up the issues involving the jury questionnaire. So what I'd like you to do is prepare for we have a list of the questions that we propose to ask. What I'm asking you all to do is if you have a specific objection to a question that the court is going to put in the questionnaire, you come prepared to argue those on Thursday morning. I'm not going to go through all of them unless I absolutely have to in that respect. But you've had plenty of time at this point in time to kind of consider that. So Thursday morning, we'll take up that issue. Is there anything else I need to kind of, as an administrative announcement, I need to do? Mr. Floyd, you'll take care of a suitable order. Send that to Mr. Menendez.
I will do that. And, Your Honor, I just want to ask one question to the format. There were 6 amended special and general demurrers, and they were filed each as a separate document, as you saw. Would the court prefer a separate order as to each one, or is it okay to consolidate?
It's okay to consolidate that. Yes, sir.
All right. Thank you.
All right. Yes, Mr. Adams.
Perhaps I've missed it. Has the court sent out a proposed list of jury questions? I know we submitted some other attorneys have submitted them, the state submitted them. Is there a court's?
What I'll do is I will ask Mr. Kearns is not feeling well, so I'm going to ask him tomorrow if that hasn't been sent out already. It should be sent out. Okay. All right.
We will have that questionnaire prior to Thursday.
If you haven't otherwise, if you submitted questions, then that's fine. But yes, I'll ask Mr. Kearns about that tomorrow. And we'll hopefully get it out tomorrow sometime. I think he's been working on it. I've seen some of it, so we should be good in that respect, okay? All right. Anything else in terms of administrative announcements?
No, Your Honor.
All right, well then we'll see you all tomorrow morning for anticipated start time about 9:30, okay?
Yes, sir.
Thank you.
Okay, all right, we're in recess.
Okay, you guys, that is that for that. As now, I just want to, because I'm doing another live at 8:30, and I had I didn't know this was going to happen today, but I had every intention of touching on the subject of Gunner and Young Thug and Snooty Wild, and I want to talk about Houston, Texas. Okay, so I scheduled that. I've been up listening and cooking and stuff. How y'all think T.I. got the sweet deal when he got caught with weapons of mass destruction? Gonna use T.I.'s lawyer. He a bad lawyer. I'm telling y'all, he a bad lawyer. But anyways, you guys, I want y'all to come back at 8:30, okay? I got another live at 8:30. I have been wanting to talk about Gunna and Thug, and I definitely want to talk about Snooty Wild. Snooty Wild, as I've been wanting to do a live on Snooty Wild. I won't even do a video on him because I want to do a live on him. Okay. All right. So thank you guys. I appreciate you guys coming over here, hanging out with me for 2.5 hours. And I hope that you guys can make it back at 8:30. Okay. I'm getting ready to eat my dinner, my baked fish. I love you guys. I'll talk with you later at 8:30.